Okay, hello everyone. Welcome to Law 2021 online civil litigation Shape the Debate with myself, Amanda Tyson, the Solicitors Group, joined today by Helen Swaffield and Andrew McLoughlin. In this live session, you can put your questions to Helen and Andrew and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. So the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So moving on to introductions, firstly we have Helen. Helen is a barrister and head of contract law chambers. Helen has been a barrister for over 20 years and has worked in London and internationally before starting contract law chambers at Chancery Lane. Currently, she is involved in large multi-party cases involving hundreds of claimants in the High Court. She has given seminars on contract and commercial subjects and litigation. As part of Law 2021 Online, Helen's sessions include disclosure updates and 10 worrying cases not to miss. Then we move on to Andrew. Andrew McLoughlin is a solicitor who has higher rights of audience for civil and criminal proceedings and sits as a recorder in the Crown and County Courts. He was appointed as a court examiner by the Lord Chancellor. His wide-ranging experience and practice, coupled with ongoing training from the Judicial College, gives Andrew a unique insight into judicial thinking and therefore what he should be doing. His main areas of specialisation include civil and commercial litigation, as well as all types of personal injury from road traffic through to industrial disease and clinical negligence. As part of Law 2021 Online, Andrew's sessions include cost budgeting and relief from sanctions. So to kick off, we're addressing some of the pre-submitted questions we've been receiving from. So we go firstly over to Andrew. How do I satisfy myself that what I am claiming are proportionate costs?
Okay, thank you for that question, Amanda. I think the main area to look at in answering this question, because we've been speaking about cost budgeting, is how do you satisfy yourself that what's in the budget is, first of all, reasonable, it's necessary and proportionate. Now, to answer that question, it's going to be fact specific, and what you need there, particularly now with the changes to cost budgeting, is thorough preparation to not just satisfy yourself, but also satisfy the court that the costs that you in your budget are proportionate. The main features that courts tend to look at are, first of all, the complexity of the case. And if we pause there, complexity is sometimes in the eye of the beholder. So I think it does require a transparent explanation as to specifically what makes your case perhaps a little more complex, or a little less complex, in fact, than what you're normally used to dealing with. So complexity, significant factor. Another factor are the sums in issue in the proceedings. So what's actually in dispute, what monetary value is at issue between the parties. Again, the greater the sum in issue, the greater the complexity, the more likely you are going to be allowed more costs to be, as it were, approved by the court and ultimately paid by the other side. If reputation, so professional negligence by way of example, is a case in point, if it's a reputational case, including professional negligence or a suggestion of fraud, those are an aspect that will increase your entitlement to costs. And I suppose the other feature that's just been added recently is additional work that's required to be undertaken or expense incurred due to the vulnerability of a party or any witness. So that's a separate feature now that's been brought into the mix, and that really fits in with the changes to the rules that deal with vulnerability of acquiring proper witness evidence in a case. So those are the main features, and if you've got a culmination of those factors, in other words, very complex, high value with vulnerable witnesses, then the cost likely to be approved by the court will be significantly higher. I think, therefore, finally, it's all about preparation. Satisfy yourself that what you're claiming is reasonable, necessary, both in terms of the step that you're taking and the amount that you're claiming. And if you can satisfy yourself, you're more likely to be able to satisfy the court. So I hope that covers all aspects of that. Thank you.
That's great, thank you. Next question is for Helen. So, are pre-action costs recoverable, and how?
Yes, well, this comes from one of the cases in our 10 worrying, and a case where £400,000 odd worth of pre-action costs were recoverable in a pretty significant professional negligence dispute with some heady allegations involving the fraud word and so on. So, you know, quite a heated negligence stroke fraud dispute against professionals. And they'd agreed on the damages, but not on the costs. And getting that kind of settlement arrangement is pretty unusual. But they just said, look, you know, we're quite happy to pay you this, but we can't reach agreement on the costs. And so instead of it being an all-inclusive sum, they divided it between the damages for liability and then said, well, it's pre-action. We haven't issued proceedings. These pre-action costs are absolutely astronomical. They're £460,000. However, if you have a look at CPR part 4614, then if no proceedings have yet been started, you can, of course, commence costs-only proceedings, and they did, and got £460,000. And that was just the interim. That was just, you know, the 90% that you would normally get when you get anywhere near a court that's making an award. That was subject to, of course, the whole detailed assessment. So, you know, getting an interim award of a fairly substantial amount of money, despite the fact that proceedings hadn't yet been issued, is pretty good going. And it just occurred to me that, you know, as soon as people walk through the door, the meter's running. And that pre-action protocol or pre-action practice direction timeline is often the whole case. And it often is that situation in professional negligence where that's a very well-used protocol, claims against professionals. And that's a pretty sizable figure, really. There was a lot to that case, but it's really a reminder that, you know, if you're working well, you don't have to issue proceedings to make a full recovery. And if you're the claimant in that situation, you know, you don't have to be tempted to do what many of us do, which is, oh, look, that'll sort it out. No orders to cost. You know, they're going to pay you that. We haven't issued proceedings. You have to take a hit on your own legal fees, but at least the matter's dealt with. You don't have to do that. You know, you can resort to costs-only process, and quite a substantial figure as well. Of course, if you're the defendant to that, then you need to be aware that any settlement offers that you make where there has been a substantial amount of pre-action work, even though proceedings haven't been issued, are still likely to attract a full costs jurisdiction. It's ancillary to the issue of any proceedings. Even if proceedings haven't been issued, it's all fully recoverable.
That's great, thank you. Coming back to you again, Helen. So how is an adverse inference drawn?
Oh, I love these actually, Amanda, because I get so fed up of writing or asking other people to write for the client letters which sort of say, please, can we see? Please give us disclosure. You know, can we see the following? And then you're just ignored. You think, oh gosh, I've got to go to the bother of getting specific disclosure, or, you know, getting third-party disclosure, or whatever it is. And the same is true of evidence. And I have a lot of clients, I don't know what Andrew thinks about this, where people are very disappointed when the other side would do what I call a Jeffrey, which is after the Jeffrey Archer, where, you know, they don't actually turn up at all deliberately. They don't come into evidence. They don't give evidence. They're not used as a witness. And then the client is really disappointed that you can't cross-examine them, because we were waiting to cross-examine them and they're not here. Well, that's exactly why they're not here, because the other side's got the sense not to let them anywhere near the witness box, because they're likely to be their own worst enemy as far as the case is concerned, or they're going to be put in a difficult position where they will look as though they can't answer the question properly. And so the absence is sometimes a great source of frustration, because you think, well, I can't prove it now. But the drawing the adverse inference cases, which are in the, and there's a few of them, there's a few older ones and there's a couple of newer ones as well, are where either there's a gap in disclosure, or there's a witness who doesn't turn up and would have expected them to have given evidence, and there is no reasonable explanation for it. Now, if they've got a reasonable explanation, if they've got a note, you know, and that can often be around illness, but of course these days when things are online, it's much more difficult really to get people well away from the scrutiny of the court. But if they've got an explanation for not producing or not having got the document, well, fair enough. And if that explanation is credible, then the court can't really do anything with the absence. But if they don't turn up, or if they refuse to disclose, an alternative to sort of shaking them is to say, okay, fine, that's fine. You know, have it your own way. I don't want to see your document, or I don't want to cross-examine your witness, but to draw the adverse inference. And the rule for that is that you must have some alternative evidence to set the scene. And then you can layer on top of that evidence the fact that there's absence, there's omission, and invite the court to draw an adverse inference. So, for example, in one of the cases, which was Southwark, an AA, and Alcoholics Anonymous on behalf of an antisocial soul who had a drink problem, was just giving sort of half of the story and wouldn't give the whole of the story to the court. And the court said, well, he's not behaving like this all the time. Sometimes he's okay. And we don't have a sense of how much of the time in this residential setting he is behaving poorly. Could we see the whole report? And of course, somebody said, well, no, you can't. And the court said, well, look, we have to draw an adverse inference, because clearly he's not on a, you know, he's not inebriated all of the time. So it was quite a good example where the court then said, well, this is actually quite serious. You're a public authority. This is this man's home, and you've thrown him out with the possessions on the street, and you won't provide us with the full disclosure. And you know, because you were asked to provide it and you still refrain from providing it. So we're not only drawing the adverse inference, but we're actually veering towards a conspiracy to keep from the court information. And really then you get into that realms of misleading the court by omission, by deliberate omission. And that has quite good evidential gold. I have to say, I turned up to a trial not so long ago, and the other side just hadn't got the witnesses. I felt so sorry for the other side solicitor, because he was obviously a conscientious person, had done all the witness warning letters, hadn't bothered with a summons, because as far as he was aware, it was their case. You know, they were going to turn up. They were the client. They didn't turn up. And they sent a kind of very casual, you know, thing to court saying, well, we're on holiday. You know, which was all very strange, because there was no mention of this. And the judge was absolutely furious about it. And he admitted all the evidence in as hearsay, but drew the most adverse inference, and they lost, as they might, and without, of course, any cross-examination from me, but just because of the way in which they had decided not to show up. So, you know, this absence omission, you do a little bit of work just to get them to know they've got then you just say, right, have it your own way. Okay, if you don't want to give it to me, don't give it to me. I'll make hay out of that. But I don't know what Andrew thinks about how because he sits, how does he treat, you know, absent witnesses?
Yeah, I think it's a question best answered in this way. If someone for no apparent reason has not turned up, which does occur from time to time, and you've got no explanation for it, then I'd treat that neutrally. I think going back to what you've said, Helen, is it's, as you've indicated, it's a lot to do with the preparatory steps leading up to it. You know, we want to cross-examine V because we don't accept their evidence. We want to see documents or the totality of documents, and even if it's some sort of specific disclosure application that it is not abided by way of example, and then you get to the trial. The judge then is in a much better position knowing the totality of what's gone on. So there's a chronology historically, and then you can draw the adverse inference, because it's just someone as I term it, you know, they're just dodging the column. They're not subjecting themselves to scrutiny for a then transparent reason. It's not just sort of don't know why. And similarly with the documents, and the sort of case you've pointed out is probably all the more concerning when it's a public authority who are failing to disclose you know, documents and the like. I mean, it's one thing for a private person or a private company to do that, because there might be very good, in inverted commas, very good commercial reasons, which then sort of backfires on them. But for a public authority to play a bit fast and loose with disclosure, I think then just opens them to condign criticism and the adverse inference that you've referenced. Okay.
That one. So moving over to Andrew now, on contingencies. So are they really worth the time and effort?
Yeah, okay. Well, this is really, again, cost budgeting point, and it's probably a little more dull than Helen's alcoholics in the world. But yeah, contingencies, are they worth the time and effort? Well, yes, they are, because I think the way cost budgeting's now moved is back to our favourite word of the day, at least mine, all about preparation. Remember, a contingency changed about 4 or 5 years ago now, where a contingency had to be budgeted for, where it was more likely than not that a particular event may take place. Now, if you do find yourself in that position where you think, yes, well, this event is more likely to take place than not, then frankly you are obliged to price it up in your precedent H. So I think that's a demand made by the rules for you to do that, and it might be a bit of a pain. The other factor that I draw to people's attention is the recent case law, which we'll look at maybe in another question, is a significant development now, again, needs pricing up for, and that's a different test. But what I'm going to suggest is that if you've got a fully fledged budget with a number of contingencies, and then you have to apply to vary the budget because of a significant development, then I believe that you'll be bringing a lot more credibility to your client's case, because you've actually taken the time, the trouble and the forethought to price for contingencies, and then something else has come along that you weren't actually contemplating. So putting in a contingency where appropriate, it is demonstrating your wider knowledge of the case and the potential risks for matters to take place after the matter's been cost and case managed. So I think that's my answer to that one. Thank you.
That's great, thank you. So coming back to you again for the next one, Andrew. So how many assumptions are deemed acceptable when preparing a budget?
Okay, and the answer to this one is there is no absolute answer. It's all fact sensitive, as we're probably aware. What the guidance is telling us with regard to assumptions is they shouldn't be particularly fanciful. There was a time, hopefully disappearing into the ether, when individuals preparing budgets would produce virtual sort of essays of a number of assumptions that were being made in the case, and that was almost well, it was unhelpful to the court when costs and case managing, because there were just far too many assumptions being made. Following the changes to Precedent H, assumptions have to be linked to a particular phase of the budget, so that sort of in essence reduce the risk of almost an encyclopedia of assumptions being attached to a budget. So the assumption had to be phase based, so that hopefully reduce the number of assumptions that were occurring. And the other test that we need to establish with regard to an assumption, it's only those that significantly impact on the level of costs in a case. You should only make an express assumption on the basis that it significantly impacts on the level of a case. One example given in the Precedent H notes is the duration of the trial. So you can cost up on the basis of an assumption of a 4-day trial, and of course that may be longer or indeed shorter as and when the directions are actually fulfilled. Therefore the watchword is only make assumptions if it significantly impacts on the level of the costs to be incurred, and don't be fanciful about them. Try and get them again specific to the case that you're actually handling, rather than just pick out some sort of from sort of some template of numerous assumptions and just put those in when they may bear no relation whatsoever to the case that is being handled. And judges do look at these assumptions, and it's not very persuasive if you've picked an assumption that has no relevance at all to the case that's actually being looked at. It doesn't do the credibility of the professional any good, or is not impressive if you've just picked out, in fact, a series of irrelevant assumptions. So thank you.
Great, thank you for that. So moving over to Helen now. Should I get mediation?
Just say that one again for me, please.
Should I get an agreement before leaving mediation?
Okay, yes. So this is the case of Aberley, which is a lovely case because we talk about midnight clauses in contracts around arbitration, but this was a midnight agreement, and it actually was a midnight agreement. Can you imagine that? Staying in one of these mediations until midnight. And of course, it was just about pre-lockdown. So they were physically in one of those horrible buildings with strip lightings, and the sandwiches have gone, you know, dry and curled, and you're all desperate. It's like being in prison to leave the mediation. All you want to do is get the agreement and go home. Well, agree to anything. Let me out. Which is all obviously part of the process, really. So the mediator is tired. Everybody's tired. Nobody's thinking straight. And offers a document which he gets everybody to sign. And it's really strange because it's the mediator who must be so fed up with these two that he drafts the document. And I've never had that actually on mediations. I've always been all with the other side to draft it. So they draft the document, and it says that this is not intended to be legally binding until it's signed. We call that a condition precedent. So it's pretty straightforward. It's not on until you fulfill the condition precedent. But the condition precedent is signature. So then the mediator said, well, you better sign it. So it sets out the money and, you know, the payment terms, and then it's signed. So what the mediator has inadvertently done, with a view to holding the agreement back until the next day when everybody's woken up and can think straight again, is fulfill his own condition precedent. So this is not going to be binding until it's signed. Here you go, sign it. Oh, he signed it. So that's that done then. It is. And that's what the court found. They said, well, there's no subject to contract here, which is the golden phrase to hold a contract back. So you leave mediation, you've got all the bits and pieces, and you've both signed it. What's not contractual about it? So they enforced the agreement, although it didn't contain, you know, the nice bits that you put in, like non-disparagement, no admission of liability, confidentiality, all those other bits, the odd indemnity. But it did just have the basics, and so it did the job. And it seemed to me that it's very important, I think, and it's a judgment call. It's one that I suspect experience brings with it. Do you push on into the wee small hours? I mean, hopefully on the platform, so you're on Zoom or something, so you're in your own home. But I mean, I've sat there in my sort of on my desk and on my chair, and I've just got so stiff from sitting still for hours and hours and hours, you know, not while this process takes its course. Do you do that, or do you just say, look, you know, we've got so far, let's call it a day, and then just let's try and hammer out the agreement? So you know that when you leave the mediation, you are subject to contract. You haven't got agreement. You're still traveling. The agreement's in front of you. Or do you just, you know, burn the midnight oil, test everybody's patience, and just leave with the baby? Because if you don't, your better view is that you'll never get it. And I think that that's a judgment call. I've certainly been in cases where I remember once we did a mediation in a church hall, which was lovely, because I can remember it was like a big badminton court as well, walking round and round the badminton court, you know, talking with the other side, which was great. I can recommend strolling, you know, as an aid to negotiation, but then it had no facilities at all, no word processing, so no printing or anything like that. So it was really difficult to get a kind of executed version, and that really made quite a difference. And as soon as we left without an executed version, so subject to contract, we never got there. We gave up trying to get there. In the end, the other side just were in the moment with us when they were willing to agree, and then we lost it afterwards. That's only one case, I have to say. Generally, where somebody's sensible on the other side, and if you are tired and if you don't feel that you can draft it appropriately, you can leave subject to contract, pick it back up the next day and get it over the line. The risk is that there's time and wherewithal to make more of it and to take points, which then could cause the whole thing to fail. I think when you've put that time in and it starts to get to about 7, 8, 9 o'clock, it's easier to just push on because people are less likely to take non-essential points, and you can get it over the line. But I'd be interested to hear what Andrew says about, you know, this whole awfulness of endless mediations going on into the middle of the night. I don't know how late. I certainly done one that was over 3 days, and then I've done one which was 24 hours, without, you know.
I think that the latest I'd got to was about 2, 3 o'clock in the morning, and but it was a mediation that had to be settled on the day or the next day. In fact, and people had come from various parts of Europe. It was pre-lockdown and the like, and we ended up because we're in a hotel where we'd met, and we ended up producing an agreement on the flip chart in a hotel conference room. These very large, because there were 8 parties to the litigation, and everybody wanted to see what. And we felt that was the best mechanism to get everybody to look at it, because, you know, we were in the wee small hours of the morning, so to speak, and everybody did. We thought we'd got an agreement, and I think it ran to about 12 or 13 pages of flip chart paper, and then it was a declaratory relief case. And cutting a long story short, the solicitor for the claimant then sort of rolled up the flip chart paper and left the hotel with it under his arm and took it to his car, and then drafted a consent. You know, on the same day, I suppose. But yeah, I mean, I suppose the other thing that, I mean, not really on the question, but is this fatigue does create a lot of concessions or minor concessions. You know, just sort of let's get it over the line, so to speak. And I suppose the other thing I'd say is if you remediate, it shouldn't, and I think you've alluded to it already, is you shouldn't be drawing up an agreement.
No,
it's not your role, because I've had that as well, where with the best will in the world, for the proper purposes, the mediator drew up this agreement, everybody seemed okay with it, and then a couple of weeks later my client said, "Oh, I don't think we agreed that. That's not the wording that I'd agreed." And then of course you've got to get the interpreter, got to get the mediator involved to interpret what their recollection was, which is an unhealthy position for the mediator to be in, because they're almost sort of being potentially a witness as to what they've drawn up and how it reflected what their understanding was. Okay,
that's great. Thanks, guys. So next question is for Andrew. So in regards to filing your budget late, will I get relief from sanctions?
Okay, yeah, I think 2 or 3 points on this is, remember, the cost sanction only occurs for filing your budget late at court. If you serve it on your opponent or opponent's late, there's actually no sanction attached to it. It's only court fees only if you file it late. If you do file it late, you're at risk of that automatic sanction. There is no hard and fast answer other than to make a prompt application to get relief from sanctions. So obviously, if you do file it late, you've got to be aware of the fact that you have filed it late. Remember, if you're under £50,000 cost, you've got to file it with your the directions questionnaire, or 21 clear days before the CMC if it's over £50,000 in terms of costs. So remember those dates clearly, and if you should be able to do it sooner. Difficulties with filing, obviously electronic filing, you can demonstrate, and you do file it late. What I come across, certainly in the cases, is it's almost incompetence breeds further incompetence. You're not quite sure when you should file your budget. You file it late. It's filed unconsciously late. Therefore, you're not consciously aware that it's been filed late, and you just sit on your hands and do nothing. Been filed late, and obviously you don't want to be told you filed your budget late by the judge when you go to the CCMC. So that there's quite a lot of that occurs, as I say, sort of incompetence breeding further incompetence. Hope it doesn't happen to anyone listening on these on our meeting today. Clearly one doesn't want that to happen, but the sooner you apply, the more likely you're to get relief from sanctions. There's been a couple of cases recently where 2 or 3 days have been felt to be okay. You will get relief 2 or 3 days thereafter. So it's not your sort of Mitchell cliff edge type moment back in 2013, 2014. But you do need to keep a weather eye on that timing. Thank you.
Great, thank you. So next one is for Helen. I'm feeling it sort of carry on from what Andrew's just been saying. So is it wise to explain the circumstances of the lateness in an action for relief from sanctions?
Oh, I did love this case, actually. It's just one of my favourites. And I agree with Andrew. Normally I'd say, look, even if you're a few days late with filing your budget, most people will, you can swing it with a judge unless they take a grave exception to it. But the Lacani case was just this approach to obtaining relief, and it's a general point, not just for budgeting. Although it was a budgeting case, they were only 24 hours late. I mean, you could have done that on the documents without a hearing, really, just so, oh goodness. And it was all to do with the calculation of the time over the Christmas holidays and what was a bank holiday and what was not, which should be a kind of closed set in terms of fact. But they'd opened it up and suggested that the court was in error. And of course, the other side had taken the point to try and dispense with the budget so that they could neutralise it to just the kind of cost fees. And so the court agreed and said, well, no, you are late. You know, you're 24 hours late. And really, I think the judge probably thought, well, we better clarify that, and then they can apply for their relief. So 24 hours late, brackets, implied, but obviously you're going to get relief because it's only 24 hours and, you know, it's Christmas. There's always good reasons to excuse. But instead of that, and with a classic amount of misreading of the court, they ploughed on arguing those 24 hours without, you know, any kind of real understanding of where that court was going to take them. So they, and possibly were overly defensive in making that application. And as a result of the argument, which went on for a long time, the court didn't give them relief from sanctions, and it went up to the appeal. And the appeal held as well the underlying judgment and said, well, it is a bit, you know, it's a bit at the one end of the extreme, especially as Andrew says, we've had quite a few cases where people have been over a few days late and they've still got relief. But on the other hand, they've wasted everybody's time and energy. And it was such a simple point. It was just to say sorry. And of course, we don't do that very easily, do we? Because we're worried about how the client will perceive our error. But your error is your error. If you're late, you're late. Apologising to the court doesn't seem to me to make any difference to that. But the whole attitude towards making an application for relief has to be really thought out quite carefully, because on the one hand, you've got to provide enough information to explain why. But on the other hand, you can't do it in a sort of diffident way. I was in court not so long ago where the solicitor had said, oh, diary management issues. And the court said, well, if you're going to run all these cases, it was group action, you're going to run 104 cases, you should have the diary and take the money for that. You should have the diary management system to sort out the hearings and the filing of and compliance with orders, and cut that solicitor right down to size. And that was the end of the relief from sanction. And I just think that the evidence was almost diffident. You know, this is how we're going to do it. This is diary management error. What's the problem? And in response, the judge said, well, it's not quite that simple, is it? Whereas, you know, I've stood there for people behind me and, you know, told them to sort of drop their heads and look at the floor and, you know, not outstare the judge, and, you know, and sort of said quite well, they're awfully worried about it. And then there are certain specific criteria, there's stage 1 and stage 2 and stage 3. But it is that repentance really that they're looking at. And the court will say, well, okay, fine, you know, we understand how it happened. It's a completely different world of discretion somehow that you're tapping into. It's a fairly carefully judged art, making that evidence, giving that evidence in support of that application. I think quite hard to get that right, to get the tone of that right, I think I'm saying.
Well, that's great, thank you. Sorry for disappearing. I had to turn my light on. It's all gone very dark here all of a sudden. So we have a live question for us next. So forgive me, not sure who to direct it to. It's regarding Precedent H updated costs. Do you have any case law re-update of costs once incurred? The witness statement costs were underestimated by half the actual costs, and the other side is refusing to agree to the increase. However, an application may affect the trial window.
Yeah, I said, well, I'm taking it that the budget's already been approved. It's significantly less. You've got a case of Seeking and Moores, which says, has there been a significant development that causes the witness cost to increase by a significant amount, a substantial amount? On the from the question, it appears perhaps not. what I would, you've two options. Get an early application in, which will turn to about the problem with the trial date. Get an application in to seek to deal with the question of costs that have been incurred on the witness statements. It shouldn't impact on the trial date because it should be heard before the trial date. An issue that does arise is as follows. If you're looking for retrospective relief, so to speak, for the witness statement costs that have been incurred, then you're not going to get it. So in other words, if you've spent the money on the witness statements, knowingly spent that money, and it considerably exceeds what's been approved, your only route to get that money back is really to show a good reason when it comes to recovering costs at a detailed assessment in that case. So if you remember that the rule that deals with is to show good reason why the budget should be departed from. That will be done at the end of the process, so after the trial. So I think to summarize the answer, if you've already incurred the costs for the witnesses, you can't get the court to, as it were, retrospectively approve it. Your only solution is to show good reason, if you win the case, why the other party should be responsible for the costs incurred over and above the approved phase of the budget, the witness statements. If it's to be incurred, i.e. you anticipate it going over the witness statement cost, then you can make an application then to do that. And as that's actually, frankly, again, probably too fact sensitive, but there's no earthly reason why that shouldn't be dealt with as a preliminary point at the trial. You say, look, not on witness statements, but on another aspect of the budget. You know, for instance, we think this case is going to last 5 days, not 4. We're down for 4, but it might last 5. Can we get a prospective budget increase on the trial phase of the budget? So I hope that tries to cover all the basis of that question.
Great, thank you. So coming over to Helen next. How does losing a point in the litigation change the outcome in costs? Okay,
I was just going to add a postscript to that on the previous answer. I think if it's incurred, it's difficult, isn't it? There's a real apartheid between incurred and to be incurred. But I've noticed that trying to amend the budget at trial is something courts are very loath to do. And I just wonder whether it's because they feel, look, we've got to get on, come on, you know. And I found that at that stage, the court has said, look, you can deal with it in detailed assessment, which always seems to me to be a second bite of the cherry, because you can make the same application there to say, look, you know, it's there are exceptional circumstances. There's a good reason, I think. Is it a good reason why this needs to be uplifted, and have that debate with the cost judge, who almost then comes against the original trial or the original CMC judge's approval of the budget. So you kind of butt up against it there. I've had this twice where judges have said, no, not now, Mrs. Swaffield, on we go, you know, and I just think, oh, it's always a bit difficult at that stage. You're sort of you're knocking on the door of detailed assessment. But I take the point about good reason to uplift in detailed assessment.
Sure. Yeah, sorry, I think with amending trial, a budget at trial, just to add to another addition, is that sometimes it's important to make an application in front of the trial judge because they've got the feel of the case. You know, it's quite easy for a judge to say, no, I'm not dealing with it. I'll just send it off to the cost judge. That might be sort of 6-9 months later, and they just won't have the fine motor skills for actually dealing with the topic that's occurred, just as an alternative. But yeah, I suppose very much in favour of, let's crack on, let's deal with the trial, because that's what we're here to deal with, rather than deal with, ancillary budgetary matters unless they actually can't be avoided. I think.
Yeah, and you get that with cost reserve. I'm just about to do something which is to pick up a cost reserve and realise that the bundle doesn't include all of the voluminous stuff that we had with the application. So how on earth is this judge going to pick that up and deal with that cost result? Because they don't have, as you put it, the fine motor, they don't have the information in front of them. Hate cost reserve. It seems to me to be a really lazy way out, actually, if I could criticise the judiciary.
No, I think you're right. There has been a case a couple of years ago where I think a judge said, well, I'm not making any order as to cost myself. I'll let the cost judge do it.
Wow.
Because they've got a better understanding of these issues. So that was actually I think cost reserve is a bit occasionally could be interpreted as sort of ducking out of it, and at least costs in the case gives some steer to whoever's going to
it qualifies you for detailed assessment, doesn't it? The cost in the case does. And even though people might be wanting payment now, it's infinitely better than cost reserve. I agree with you. If you feel you're going to win the war, maybe not the battle but the war. Yeah. Oh, sorry. I was asking. Oh, yes, this is my case of Terra Corp. Yeah, this is issue-based costs orders, which is really massive now, or proportionate costs orders under CPR 44.2. And this is where so much of what I do now, I'm just about to go back into bat in the commercial court on a costs following an application on this. And really, again, every situation, as Andrew puts it, is fact sensitive, where they've won part of the application, we've won the other part of the application, they're getting the check, but it's not, they can't take that check now because of something called set off, and so we're going to do that at trial. And then so what was all the application about? What have you got at the end of it? And we're trying to sort of plot by a sophisticated mathematical algorithm what percentage of cost is on their basis of their claim, what percentage of cost is on the basis of our counterclaim. And it's really tricky, isn't it? And you think, well, golly, this is like sort of matrices that we did, back in the day, or logarithms. Actually, if I take X and Y and multiply it by Z and think of the number I first thought of to the power, I get the right result. And that's just the sort of mathematical discretion that's open to us. And since for about 3 or 4 years now, we've seen these. They've always been there, sitting quietly at the end of 44.2. 6 and 7, these proportionate costs orders where percentages are given, or issue-based costs orders, which are rare, because that's when you say, looking at the witness statement, only 6 paragraphs concern issue A, which you've won on, and the other 20 concern issues B and C, which you've lost on. So that's really difficult for anybody to steer through. So that tends to be converted. So if you've had sort of 4 issues and you've won 2 of those, and the obvious point is, well, that's a 50% hit for you. And so you apply that then across the whole of the bill. And what's happened in the last 2 or 3 years, and my Terra Corp case, which Nick Bacon QC and I did when it went to on appeal, has sort of opened up and reflected so much other activity around those percentages. So, it's almost the minority of cases now where you say, I've won 100%, on a standard basis, subject to Part 36. Let's not get involved in Part 36 just for this, but just in terms of the outcome, the winner takes all. And that's not now the majority of cases. The majority of cases will say, well, I don't think that's the right order, because they've lost on this, they've lost on that, they've lost on the other. And then you have that argy-bargy with, well, how much do we deduct? And do we deduct, say, you're going to get 60% of your costs as the successful claimant, or is it 60% and you pay me 30% or 40% or whatever it is, to sort of square the circle? Or am I just sufficiently recompensed by not having to pay you 100% on a standard basis? So it becomes really difficult to sort of compute these percentages. And yet it's such an open texture. I think costs are so important at the end of the application. Even if it's a summary assessment, you can still apply this percentage-based thinking to it. Or at the end of the whole thing, where you say, no, actually, that's not the right order because they failed on this, they failed on that. And some of the issues I think that the court are looking at is who's actually got the check. If you've got the check, then you're in a good place. But if you've managed to do it and not get a check and not get anything to speak of, then it's much more tricky to say, oh, well, I might have lost a few battles along the way, but the war is mine. And it really does give defendants who are paying parties an option to change the resulting costs.
Yeah, I concur with that. I think the training is, in essence, in fact, it's in line with the rule. The general rule is the unsuccessful party will be ordered to pay the costs of the successful party. That's the starting point. And therefore, as Helen says, who's got the check? That leads to a court saying, well, fundamentally, they are the successful party. And therefore, generally speaking, costs orders are going to be in favour of that successful party. And then you get into the granular, well, they didn't win it all, did they? It was a 500k claim. They've only come out with 135. They've lost on certain heads of damage, etc., etc. And therefore, you then straight into percentages. But I think, again, just to confirm what you said, Helen, most judges are now trained, really, for years, don't go down an issue-based route for costs, because it becomes extremely difficult to actually assess on a detailed assessment. I'm on a centre, just to give you an example, I'm on a centre letter dealing with the 5 issues in the case. It's a £600 letter in terms of the amount of time spent. I've dealt with all the 5 issues. I've won on 3 of them. What does the judge do? Does they say, right, well, you can have 3/5 of that letter, and then a defendant says, well, actually, no, the judge is for that. You've got to look at the issues. Look at the issues in this case. Look at that letter. The 2 issues we won on as a defendant, that was the bulk of that letter. There were only 2 or 3 lines about issues 1, 2, and 3 that the claimant won on. And that's then just assessing one simple letter. And that's why it's issue-based cost orders tend to create a lot of froth in terms of satellite litigation when it goes to a detailed assessment. That's why Jackson wanted that old school successful party recovers costs from the unsuccessful party.
Yeah, I don't know if we've got time, because I realise we haven't got very much time. I just wanted to say as well that the Shah case, which is the Part 36 case, and we're not covering Part 36 particularly. I think it's in one of my 10 worrying whatever, but that's the one where they had disproportionately small amounts of money. So he made an offer for a 10 quid or a quid, was it, and then won 10 quid. And that really does change this issue-based costs thing, because if you've lowered your expectations, almost ridiculously so, as a claimant, not as a defendant, this won't help you as a defendant, but if you've lowered your expectations as a claimant, and you're really just in it for the costs, and you get your 10 quid, then that does drive a coach and horses through a proportionate costs order, because you've hit the jackpot. So quite a lot of the Shah offers, which I see coming through quite a bit now under Part 36, are, we want to exit this, and we just want to make sure we get all of our costs, no matter what, because costs have become more important than the principal sum, and we don't want to risk what Andrew's talking about. And so we make this derisory offer, but it's a genuine one. It's a very small amount of money. We're bound to beat it, but we'll get our costs. And if they want to accept that offer, they have to pay our costs. And our costs are now the predominant factor in litigation strategy. That's Shah and Shah, the bitter dispute between a family, recent case the last few months, massively a game changer in terms of claimant strategy, really. You get in and your clients just want to get out without having to lose part of their costs or pay somebody else's costs. Then you just pull that amount right down to the bottom and then play for the costs.
No, that's great, thank you. I think we might just have time for this last one for Andrew. What steps should I take if my opponent agrees to grant relief from sanctions?
Yeah, well, we can deal with this very concisely, actually. 3.8, you still require the court to grant the relief from sanctions. So even if though you've got a consent order in inverted commas, still need to get it before the court just to get that imprimatur from the court, because it's the court that grants relief from sanctions. I mean, technically, I don't want to get too academic about it, but technically your opponent could agree to give you relief from sanctions in inverted commas, and a court could simply say, no, you're not having relief from sanctions. You've not fulfilled the 3-stage test in Denton. See you later. Bye. Professional negligence claim. It's, that's the risk. So 3.8 is the answer to that.
Well, that's great. Thank you very much. So unfortunately, that is all we have time for today. Thank you for attending Law 2021 Online Civil Litigation's Shape the Debate. Thank you to our expert speakers, Helen Swaffield and Andrew McLoughlin. Don't forget to join the Solicitors Group Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to buy the complete event, including the recording of this live session, if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. The exhibition is open to anyone to visit, and if you have already booked the entire event, you can claim your 1-hour free CPD webinar from the webinar learning catalogue worth £35 plus VAT. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. So what's left is to say thank you again and have a great day. Thank you, everyone.
Thank you very much. Thank you.
Bye-bye.
Thanks, Helen. Thanks,
Bye.
Amanda. Bye-bye.